On the go? So are we. Get the IBJ Media app, your all-in-one news source for Indiana business news. Get breaking news alerts, read every story from IBJ, Inside Indiana Business, and the Indiana Lawyer, and listen to your favorite podcasts all in one place. Big news, small screen. Search IBJ Media and download the app today.
Welcome back to the Indiana Lawyer Podcast. I'm your host, Maura Johnson. In today's episode, we're celebrating the Indiana Lawyers 2026 Leadership in Law Lifetime Achievement Award recipients. The Lifetime Achievement Award is given to attorneys with at least 25 years of experience whose professional impact extends beyond the courtroom. Recipients display a storied career filled with community engagement and dedication to nonprofits, civic organizations, and pro bono legal services. They're change makers, seeking ways to open doors for the next generation of legal professionals and lending their own experience and knowledge for the betterment of the profession. Past award recipients include former Congresswoman Susan Brooks, Judge Sarah Evans Barker, and Judge Tanya Walton Pratt. This year's honorees are James Bopp Jr. and Ken Falk, two men who, though on different sides of the political coin, share a passion for representing their clients well and upholding the constitutional rights of everyone they serve. Bopp and Falk join IBJ editor and assistant publisher Lesley Weidenbener for a fireside chat at this year's Leadership in Law breakfast, sharing more about the significant cases they've worked on, their mission-driven careers, and the similarities the two share in their work. But before we get into the conversation, here's a word from our sponsor, Taft.
Taft, today's modern law firm. At Taft, we cultivate a highly respectful, transparent workplace that fosters creativity, teamwork, inclusion, and diversity. We couple our culture with a client-first approach, rewarding lawyers who understand their clients' goals and work to deliver success. Taft, the modern law firm. To learn more, visit taftlaw.com.
They were talking up here about who's on the left and who's on the right, which, as you can imagine, is quite appropriate. This is a real honor for me. Before I came to IBJ Media, IBJ, and the Indiana Lawyer, I was a political reporter for a long time and came across both of these gentlemen in my reporting and in stories that I wrote. And so this is a lot of fun. So thank you both for being here.
Thank you.
You've both spent decades litigating some of the most consequential, I almost said controversial, but that is the case as well, constitutional questions in America, but from opposite sides of the ideological spectrum. What first convinced you that law could change society? And how did you go in that direction? Jim, let's start with you.
Well, watching people on the left, the liberals, do that for years. In other words, the NAACP, in what they did in planning, executing the overturning of Plessy versus Ferguson and Brown versus Board of Education, and then many other organizations, the ACLU, founded early on. And it was a completely legitimate effort, in my opinion. The court, they were assisting the courts with amicus briefs and all that, but also designing cases that obviously the court was prepared to hear and consider, and that needed to happen on the right. And I proceeded to do that.
It's fascinating that what you saw on the other side, and it sounds like you respected the approach, led to what you were doing. Ken, what about you?
Well, I don't want to disagree with anyone, as it's not my want, but, the ACLU, at least as far as the legal side is concerned, is not a liberal organization. I've represented abortion protesters, anti-abortion protesters. I've represented Planned Parenthood. I've represented the NAACP, but I've also represented the KKK, not in the same case. I've represented police. I've represented prisoners. I've represented children. I've represented child molesters. The point about the ACLU's litigation historically has been to stand up for the Bill of Rights, because a fundamental belief, and I think a truism, is that if we don't stand up for the rights of everyone, even people we don't necessarily personally agree with, all of our rights are diminished. So my efforts have always been, from the very beginning, to give people voices who otherwise would not be heard. And I think it's important to recognize how important that is, especially today.
One of the things that was really interesting is when I asked both of these guys if they would come up here and talk, they both shared a lot of respect for one another. And so I wondered if you could address what Ken said about the work that he's done.
Oh, and I agree completely with what Ken just said, that I was speaking more generally, the way people think about things, but, we while we share many values, actually, there is a different approach in judging that there's two different approaches to it that can dominate a particular court at a particular time. And the conservative view is one of those. That is textualism. And so there are differences, but there's also, he's exactly right, the traditional ACLU was perfectly willing to advocate for the rights of people regardless of their political viewpoint or whatever. And I know it'll surprise a few people, but actually I've done the same thing. I represented a judge from Milwaukee that was prohibited from endorsing candidates by their judicial canon of ethics, and I brought suit on his behalf, struck that canon in the Seventh Circuit. He wanted to endorse Barack Obama. So it wasn't the political viewpoint that was important, it was the constitutional rights that were important.
You've both chosen mission-driven careers rather than, frankly, that are not as lucrative maybe as it would have been if you had chosen a different path. What made you want to pursue a particular mission?
When I was hired to work at Legal Services, I was hired to work in Muncie. I went to college and law school in New York City. I'd never heard of Muncie. When I got there, I realized it was not Manhattan. They offered me $13,000 a year. I thought I was in heaven. I was getting $13,000 a year to do what I always wanted to do. I always viewed the law. I took some time off in college. I worked in Washington Heights in northern Manhattan before it became the Heights, in a senior center, and every single person who came in had a legal problem. And I realized if you're going to try and help people, and I had no other appreciable skills that I was aware of, then I should become a lawyer.
I became very interested in political philosophy, but really at the dinner table with my father, but early on, began reading books about it. Adam Smith and many others. I'd be sitting at Boy Scout camp as a camp counselor, and I'd be reading these political books, and then it kind of culminated when I organized my high school for Barry Goldwater in 1964. Now, that's a little bit of an exaggeration. I did organize 30 people, so out of the 1,000. But and frankly, by that time, I decided my mission in life should be to advance a conservative cause. I think it was good for individuals, good for society, the best way of organizing things, and bringing prosperity and freedom to everyone, and so that began then and has continued to today.
But Jim, you described the overturning of Roe v. Wade as the culmination of your life's work, but it took decades. Can you talk about the vision of thinking about what you wanted to do and what it takes to stick with something over the course of that long?
Well, in 1978, I became general counsel for National Right to Life, and I still am. And that was my first task, is to design and then ultimately implement a strategy to overturn Roe v. Wade. And I've already talked about Thurgood Marshall's pathway that I studied and learned so much about how the court operates and how you bring cases and how you should design those cases to eventually reach a result. And of course, that was one of the things. It's not overnight. It's not the court going 180 to 180. It's a series of cases that provide the basis and framework for the overturning of precedent. And the other thing that I learned is that you never lose unless you give up. You don't lose. In other words, something is a temporary victory or temporary setback, but as long as you haven't given up, you fight for another day and things change. And we had both of those. We had successes that ultimately led to overturning of Roe, but we also had, setbacks that were sometimes pretty significant. So that lesson, now I've given up on a few things over the years, but that one I certainly never did give up on.
And do you feel like, can you sit back now at this point, or are you still thinking about what's next in that area?
Oh, definitely thinking about what next, because while the intermediate goal, which was huge, was overturning Roe v. Wade, if your goal is to protect innocent human life, you need to have the government on your side, and that was the big obstacle. And of course, now that obstacle is removed, and now it's a question, before the states of exercising their police power as they will choose to do based upon the wishes of their constituents. And it's actually, in many respects, much more difficult situation. Democracy is difficult. And if we have true freedom and true democracy, nobody's dictating to people, which is thankful. I'm thankful about that. And so it's developing legislation now. I mean, what we're into now is developing legislation now over the last couple of years to maximize the ability of pro-life states to protect innocent human life, and then we'll continue to proceed.
Ken, I was wondering if you could comment on what Jim said about the fact that democracy is difficult, and sort of how I suspect that you have also run across that, and maybe how.
Democracy depends on Democracy depends on the workings of three branches of government within their defined roles. We live in a time today when, from my perspective, I was going to say not necessarily the perspective of the ACLU, but I think I'd be lying. My perspective is that the executive branch has gone way beyond where they should be. Correspondingly, the legislative branch has receded, so things are terribly out of whack. The one thing that is working, thank goodness, and I'm sure Jim would agree on this, are courts and lawyers and staying in our lanes that the Constitution prescribes, but also fulfilling the roles to try and check the excesses of in this case, the executive branch. So democracy is wonderful. And we accept in a democratic system that your viewpoint, whatever it is, may lose, and that's fine. But what we're seeing today, I think, is a perversion because people are not staying in their lanes. And that is extremely troubling from the standpoint of someone whose goal is to defend people's rights.
Yeah, and we spent 250 years trying to resolve that tension, between those three branches of government, and the founders created them on purpose to create checks and balances, and which resulted in this tension, And the other thing, of course, I agree with completely is, the Constitution has substantive rights that are to be protected, and they're in there, and they should be deployed to protect the people and the system and all that. So that is, the role that I have felt like I have occupied in many instances, and of course Ken has occupied in many instances. Now, where sometimes we disagree is whether or not there are rights that ought to be in there, or maybe we can search around and find them in there when they're not actually present. And I consider that, from my perspective, anti-democratic because it's seizing power by the judges, removing it from the people and the democratic process. So. But, this is a matter of judgment. It's subjective. It's and difficult often,
Do you both enjoy the back and forth as you listen to each other talk about your interpretations? Excuse me. Do you enjoy this kind of debate?
I think it reinforces the point I was making, which is that both of us are operating within a clearly defined lane that we believe the Constitution has prescribed, which is how it should be. And both of us are going to be arguing and argue cases based on theories. Sometimes, I don't know if Jim's ever lost a case, but I've lost a couple. Sometimes we win, sometimes we lose, and we accept that. And that sort of vitality is essential. I have to say, having spent a career representing people many ways who have no voice, none of my clients are happy when they lose, but all of them, I think, feel a sense of having been heard. And when you're able to do that, when you're able to take someone into court and say to them, look, this is how the system works, and they get to tell their story, and they get a reasoned decision, that reinforces the system. And that's incredibly important. I think it's funny, and it's natural to talk about lawyers as conservative and liberal. But what I do is the most conservative thing in the universe. I am accepting what laws say, what the Constitution say, what judges tell me. I'm not burning things down. I'm not running around. I'm playing within a well-defined system and helping to make it stronger, which is what we all do, and which is so important, especially today.
The ACLU gets hundreds of requests for assistance.
You do.
How do you choose which cases to take on?
Yeah, we get, 600 to 800 requests a month. We have 4 attorneys. The cases that we take are cases that we try to take to make a difference, either frequently for an injunction to stop a law, but sometimes small damages cases for something that we think is a clear violation that we don't want to repeat itself. Sometimes for large violations. We recently wrapped up settlements in 31 cases involving prisoners in Miami Correctional Facility who've been placed in cells without lights, with windows boarded up, some with electric wires shocking them, some with sewage on the floor been there for weeks or months. And we ended up with a settlement, not a decision, but a settlement for upwards of $1.2 million for them. Hopefully that will make a difference. The idea is that with our limited resources, we want to convince people not to repeat constitutional errors.
I was wondering if you have found over the years that there is a gap between what the Constitution says on paper and what it actually means for some of the clients that you, especially some of the clients who don't have as many opportunities.
Well, I mean, that's why courts are so wonderful, because once I get someone into court, we're equal. The problem, of course, is getting into court. The problem is that there aren't enough lawyers willing to take cases that may not pay. There are not enough lawyers willing to take the small cases, which are, really important. I mean, we do small cases at the ACLU as well as big cases because any injury to the Bill of Rights is an injury to the Bill of Rights. So, yes, it's always a problem being able to get into court, but once we get people into court, we're on an equal footing with a law firm with 130 attorneys.
Jim, do you find that to be the case as well?
Oh, definitely. I mean, I've sued 45 states on their campaign finance laws and won an enormous amount of those under the First Amendment. And, there was a gap. And so it's, I want to emulate so much of what Ken has explained, how he has functioned and operated and the ACLU has operated. Yes, you need to do a lot. There is a gap that needs to be closed. And that's one of our jobs, to do that through litigation. And of course, he's also right. It also involves a lot of pro bono. And besides, my political activity or community activity, which of course pro bono in most cases, I do have done a lot of lawsuits pro bono, hoping to prevail and under the Civil Rights Act and get an award of reasonable attorney's fees, which I usually think is more than the judge is going to allow. Yes, and that's our job.
Jim, I have a question from the audience. Citizens United, you were just talking about some of the campaign finance related cases. This says Citizens United allowed nearly unlimited money in politics. Do you think that increase in corporate money has contributed to the increasingly angry discourse that we see today? Do you believe that it was a good step for democracy?
Well, yes, I do. I was obviously I was the architect of that case. Got it to the Supreme Court, but I think it's been misconstrued in a way that you just sort of mentioned. All right, it involved independent spending by corporations, not contributing to candidates. So it didn't mean unlimited money in politics, because the contribution limits are still legal, as long as, another case I won, as long as they're not too low, contribution limits are not too low. And my concept of corporations seems to be different than other people. My experience with them is through my practice in organizing not-for-profit organizations, which I've organized dozens and dozens, including very substantial national organizations. And what I view them as simply a collection of people. People of average means, if they're going to participate in politics, now we're getting the connection with Citizens United. If they're going to want to participate in politics, since they don't have the money, the rich people have the money, they can spend the money, right? But people of average means have to pool their resources. And what is the most logical vehicle for that is a corporation or a labor union. And so they pool their resources and then participate and can compete with rich people. If you eliminate, as the prohibition in the FICA did, that was struck down as Citizens United, from independent spending, then it's only the rich people that get to participate. And everybody, people of average means, are simply absolutely shut out of the process. You can't, you're not rich enough to buy a newspaper or a TV station, nor do you have the money to put out independent expenditures and all that. So you're basically out of the process. So I viewed it as empowering everyday citizens.
Ken, do you have some thoughts about what money has meant for politics?
I'm going to say no. Not because I don't have personal opinions, but because, again, a court has declared what the First Amendment allows, the Supreme Court, and one of my rules is that when a court makes a decision, and it's a final decision, that's the law. And I taught for more than 20 years as an adjunct, and I would tell my students that if I ever heard them criticizing courts the way some attorneys do, wherever I was, I would come back and haunt them, which is a great relief to my kids because they're afraid I'm going to come back and haunt them, because that shows a massive disrespect for the law. So I certainly, if I was on the Supreme Court, I might have ruled differently on Citizens United, but for some reason I'm not on the Supreme Court, so I think we're good.
And I agree with that. When I design cases, and I've designed hundreds of plaintiffs' cases to challenge laws and regulations of campaign finance, in most importantly, I always design them as having two elements. One is that you can win under current law, maybe with a few adjustments, but often, in the context of a case of an issue that has not really yet been decided by the courts. So you're dealing with more general principles, and you should design it so that you can argue it should be upheld, maybe with this tweak or with this understanding. But then always understanding that a court at any point when you're asking them to apply a precedent, the court is perfectly entitled to reconsider, and if they choose, overrule the precedent. So, inherent in so many of these cases that regarding Citizens United was the validity of first one and then later two previous Supreme Court decisions that were being asked to be applied, and I understood that they're on the plate if the court is willing to take them on. And of course, in Citizens United, bingo, they were.
Ken, you touched on this a little bit, but you've warned before about a growing disrespect for judges and the rule of law. What do you feel like that erosion looks like?
Well, I think it looks like the President of the United States and other people in administration not criticizing decisions, you have a First Amendment right to criticize any way you want, as long as you don't cross the line, obviously. But to accuse judges of making political decisions, to accuse judges of being crazy, to all that trickles down to people who are more extreme, who hold more extreme views, who somehow feel validated. That's dangerous on a personal level, but it's also incredibly damaging. All of us are lawyers, most of us are lawyers here, and we don't stop to think, this is all made up. Judges make a decision and we say, oh, we lost, and we have to comply. Well, why do we have to comply? The judge doesn't have an army, the judge doesn't have the military. We comply because of the rule of law. And we comply because we are bound to support how it's supposed to work. And I think we have seen on many levels, not just from Washington and other places as well, active disrespect, we don't know if we're going to comply. We think this is a bad decision. We think this is wrong. We have the right to decide. And that's not what the Constitution says. We have a bargain here. And the bargain is we comply with the Constitution, we comply with the rule of law. So yeah, I think we're in a really bad time now. And again, thank goodness for judges. Thank goodness that Jim and I have a forum where we can be treated equally, where we will be listened to, where we can make arguments, where we can talk about expanding the law. And sometimes we lose. Again, sometimes I lose. And once in a while I win. But I'm extremely concerned. It's not good.
Jim, do you have any of those same concerns?
Well, here again, I agree with Ken. I think what I would talk about is common ground. We really need common ground to be a civil society that'll survive. And one of the common, understandings that we have had for a long time is we have a process to resolve our differences without resort to violence and civil war. Occasionally, one time in our history that broke down, and it resulted in 600,000 dead Americans and a terrible disruption of our society, but ultimately to a very positive end, in my opinion, eliminating slavery and keeping the Union together. But in any event, and I think in that respect, liberals and conservatives have common ground, as we've, I think, mentioned. I'm concerned, certainly, about anyone on the right that is attacking judges individually, smearing them, saying that their decisions are not based upon, the law and the facts and a good faith effort by them to apply them. And I'm concerned about the progressives, whether we have common ground with them as well. So it is a problem on both sides, and it's a historical problem, it's a forever problem. And one of the rules is for lawyers is civility. Which I think is extremely important, and as I think you've mentioned that he's also mentioned, that there's concern about the undermining of that, which is, again, would serve ultimately to undermine our common ground, which would be disastrous.
I think we could talk to these gentlemen for a really long time this morning, but I know we have a lot of awards to get to. So can we please have a round of applause for these outstanding Lifetime Achievement Awards?
Thank you for listening to the Indiana Lawyer Podcast. For more news on what's happening in the legal profession across Indiana, please visit our website at theindianalawyer.com. There you can read in-depth reporting on the state's most pressing legal topics, find more episodes of this podcast, and read stories from our sibling publications, the Indianapolis Business Journal and Inside Indiana Business. You can also follow the Indiana Lawyer on social media.